Hello, everybody. I'm just going to give it a moment here just to make sure everybody gets through the technology. So maybe 30 seconds. I know we had 135 registered participants, so we're glad we're on the technology. It's going to let us get there without too much bumps and bruises. The downside is that you only get to see our four faces today, and because many of our Zoom calls, we try and have people on screen and everybody can, visually chat with each other. But with a potential of 135 participants, that's definitely pushing the limits of the technology. So yeah, so I'll just give it another moment here. Okay, so just to start, some quick housekeeping. Field Law, KWB, and Phoenix Advisory Group would like to acknowledge that we are in Alberta, that we call Alberta and Northwest Territories traditional ancestry territory. The main peoples presently subject to Treaty 6, 7, 8, 10, and 11. We acknowledge that the many First Nations, Métis, and Inuit who have lived in and cared for these lands for generations. We are grateful for the traditional knowledge keepers and elders who are still here with us today and those who have gone before us. We make this acknowledgement as an act of reconciliation and gratitude to those whose territory upon which we reside or visit. Today's a little bit different format for those that attend Phoenix events or have attended Phoenix events in the past. It's definitely an informal conversation. It's discussion based, and we're not doing any PowerPoints. We're not doing any scripted answers. This is live and organic, I call it. So we're taking conversations in the chat bot. So if you drop your questions into the chat, we will do our best to answer as many as we can. Obviously, we're going to be limited to the more general questions. If we start getting too specific, we're going to have to take that offline and have that conversation separately, differently. And if we have a bunch of questions that don't get answered, we'll do our best to try and maybe put a notes together or some sort of a follow-up afterwards. But definitely drop your conversation, drop your chats into the chat bot, and our helpers, Samantha and Kate, will help us, guide ourselves through that process. And I want to thank everybody for participating and coming in today, and commit to yourself that if you have a question to ask, that you're going to ask it, right? All right. One additional piece of comment here is that what we're doing today is informal. It's not formal accounting or legal advice. If you need formal accounting or legal advice, we may even make mention of that here, but definitely please speak to your lawyer, your accountant. Hopefully it's KWB and Field Law, but if not, like maybe get them to quote on your business. But ultimately, make sure you get some professional advice when professional advice is needed. But we do want to give some really good general advice today and general knowledge sharing today. It is being recorded, and afterwards you'll get a short survey and be able to provide some feedback so that we can do better, right? Okay, so let's do some quick introductions each. So my name is Jeff Feastick. I am a co-founder of Phoenix Advisory Group. I also run a couple other businesses that many of you may already know me for. But ultimately, I'm here to facilitate today's conversation and help guide the conversation for all you participants. My list, I'm going to change the list. Amy, you're first. If you give us a quick Coles Notes version of Amy and what you're here for today.
Jeff, good afternoon, everyone. My name is Amy Heil. I am a partner at Field Law, and my practice areas are wills, estates, trust, and corporate law. And so I do a lot of business succession planning for family-held enterprises.
Perfect. Thanks, Amy. And just to squish the accountant in the middle, let's go to Darren next. Oh, we lost his.
Sorry, yeah, I was unmuting my mic and I hung up on myself.
There you
So
go.
my name's Darren Buma. I'm partner with KWB accountants and advisors, and we focus on working with entrepreneurs and business owners and guide them through their business journey, and often that journey hopefully ends with a successful exit from the business. So that's a great conversation that we're having today.
Perfect. And Malkeet.
Thanks, Jeff. Like Amy, I'm a partner at Field Law. My practice is primarily around wills, estates, trusts, planning, and I also have a fairly significant estate litigation practice, which ties into some of the issues that can arise when planning doesn't go well, and we'll be touching on that as well this afternoon.
Excellent. All right. So what exactly are we here to talk about? What's succession planning? What's one's legacy? Like, who wants to kind of define where we're going today? All at once. Good.
Okay, well, I took
Amy, go
I
ahead.
took my mute off first, so I'll jump in. So I think, when we talk about legacy and succession planning, we look at two pieces of the puzzle. There's a financial puzzle and a human part to that. And when we distill that down a little more, when we're looking at business succession planning, I think we look at the transference of the company to either the next generation or key employees, along with structuring an out for the founder, that allows the corporation to continue that legacy of the business that was originally introduced by the founder.
Yeah, that's great, Amy. And then to follow on with that, it's with the proper planning, it's really about this successful conversion and retention of the wealth that the entrepreneur has built in the business, right? So it's maximizing the value on exit, which isn't necessarily always the first objective particularly with a family succession, but it is with respect to making sure that we have enough to get through retirement, and it's about providing that value in a liquid form. So now I can actually use that for other objectives that I have, and perhaps diversify your investments further, right? Because many business owners, their value is highly locked up in their business.
And Malkeet.
Yeah, I don't have a whole much more to add to that. It's taking steps today to preserve and potentially continue to grow and ensure that the operation or the business or whatever it might be continues to succeed for the next generation, if that's an important value that you are concerned about. It's ensuring that you have the right people in place to be able to make decisions on your behalf when the time comes when you're not able to deal with those things for yourself. All those things tie into succession planning. And as Amy said, there's a financial end of things as well as an emotional and a human element, which all kind of integrate and work, have to be considered when people are talking about succession planning.
All right, so I'll get into the question portion now. And we already had a bunch of questions online that were sent in as part of the registration process. Obviously today we'll be getting anybody that drops into chat their questions, and then I had some that I had pre-written. So this is we're gonna get going. So question for I don't know who wants to jump in first, but how is succession different than an outright sale to a third party? What is what are some of the finite or detailed differences between those two?
Yeah, I think, Jeff, that the primary difference is with a succession plan, it's really the transferring of the business, and it may be to a family member, maybe to existing management of the business, or even a combination of both. And it speaks to to some degree, the desire of the entrepreneur to have their legacy maintained, right? So it's about, it may not be about maximizing and the cash value on exit, but it's the most important priority typically is about the success of the transition, which is the transaction itself, and we can talk about some of that today, but also just the ability of those involved taking over the business, their opportunity to succeed and carry it on and go in the direction that they want to go with. The difference would be, with a third party sale, the primary objective most often is how do I get my cash out of this thing? And for sure, I hope it's going to be successful going forward, but I don't really care what they do with it. And at the end of the day, um, it's just about putting some money in my bank.
Amy?
And I think, you know, especially in our practices, both on the accounting and the legal side, this issue, the likelihood of having to deal with business succession planning, just it continues to increase, especially when you look at who's running the family businesses. And I was presenting on another panel and we were looking at some of the stats. And in North America, 15% of family business CEOs are over 75 years old. So despite the stats showing that there's a clear need for succession planning, I think many founders haven't put adequate planning in place. And I think a lot of common themes that we hear on that topic is, they haven't gotten around to it. They're thinking of it. They know who they should be transitioning to, but they don't want to deal with the conflict that that's going to maybe create. They've got plenty of time to plan, or they don't know who the clear successor is, so they just ignore it. So I think it's something that we are seeing more and more, and it has to happen. So it's a great topic to be talking about now because if you don't do it, Malkeet and I see the other side of that too, as does Darren, because then we're dealing with the coulda, shoulda, wouldas.
Marky?
I don't have a whole lot more to add to what Darren and Amy said in respect of succession versus sale, that dichotomy. I think that's fairly straightforward. A sale, obviously, to a third party, the person's interested in maximizing the amount that they're going to receive as a result of the sale, of the company. Succession, I think, is a much broader topic than a sale to a third party. It entails all sorts of considerations with respect to issues of selecting the successor, selecting individuals to assist during a period of time when the founder might be incapable temporarily or for a prolonged period of time. I think what going back to what Amy said with the stats she just gave, there's a number of people, I think, the misconception or perhaps the notion that they don't have as complex of an estate or a business that might require some legal and accounting assistance throughout. I think it still exists. I've had a number of clients over the years who've had accumulated a significant amount of money and wealth in their businesses, and they still don't believe that they've actually achieved what I would consider in my line of work to be a fairly significant amount of wealth. And so there's that educational piece that I think still continues to be missing for a lot of people, is that they don't know when the right time it is or right time is to seek that advice. And hopefully with these kind of conversations, we're able to tell people that sooner the better, and that there's, it's never too late to consider those things, even if you've tended to procrastinate about it for years.
If we think about succession, what are some of the legal documents or matters that need to be considered in its succession process? Because I think, to me, third party process feels and is more formal. A succession process might be more informal, but that could include additional risks. Can you maybe each of you take a chance at what do you see in a succession process as far as the dotting the I's and crossing the T's? Okay, go first. Yeah.
Sure. I'll let Amy talk about maybe more of the corporate documents that might be put into place or that might be required to put into place, as that's more in her wheelhouse. However, there's, from an estate planning perspective, which is, from a purely succession and personal succession planning perspective, we're always talking about wills, powers of attorney, and personal directives. Wills, of course, take place as of or take effect as of the date of somebody passing away, which deals with their wishes as to how they want their assets and various things that they've accumulated during their lifetime to be passed to the next generation. It obviously entails very important considerations such as who the executor of the estate is going to be that's going to administer that estate and carry out the terms in the will in a manner that the person has set out. Power of attorney and the personal directive are two other important documents which deal with having somebody lined up to make decisions with respect to financial decision making as well as personal decision making. So the power of attorney deals with financial decisions that might come up during a time when a person is incapable but they're still alive. A personal directive deals with appointing somebody to make personal decisions, so healthcare, where you're going to live, those sorts of decisions that might come up. But those two documents are often just as important, sometimes even more important than a will, because they deal with issues while you're alive, which an individual can lose capacity and still remain living for 10, 15, 20 years. It can happen for a long time. So somebody has to be put into place to make those decisions on behalf of the individual. And from a business owner's perspective, having somebody lined up to make decisions with respect to the corporate assets is a key consideration in proper succession planning. Failure to appoint somebody with the knowledge, the know-how, and the expertise, and perhaps even the ability to seek out help when the time comes, can lead to a lot of problems with respect to the ongoing operation of a company that might require a whole host of decisions to be made on a day-to-day basis, including making payroll, hiring employees, dealing with the shares of the company, sale of the business, all those sorts of things. So from a succession planning purpose or point of view, those three documents are absolutely critical. And the appointment of an individual to make certain decisions with respect to the business is also key. I'll let Amy step in and deal with more of those documents, as well as some of the corporate documents that would need to be put into place for.
Sure. Hi, thanks, Monkey. Yeah, so I think when we first meet with people, as Melkeet said, even at the start of succession planning, one of the first things we ask is, do you have a will? Do you have your EPA and your PD in place? Because, I find lots of times people think, again, you don't have to succession plan, but I'm also not going to die tomorrow, so I can do those documents down the road. And, I find one of the best ways to get people to jump on those documents is to kind of lead with the cold hard truth of, you're not doing this for you, because you're either going to be incapacitated or dead. So are you leaving a mess for the people around you? And I find that's what motivates a lot of people, especially people that have children, because are you leaving your kids to sort this out and fight about it, or are you going to do it? And do you have that? So those are kind of the first documents that we say, let's get this in place, and then let's start looking at an overall succession planning strategy and working. We often work with Darren and other professionals because it's a group project of how we want to carry this out. And from a legal perspective, another thing that a lot of founders like too, when we're succession planning, one of the documents we can put in place before we bring in next generation or key employees is we put together unanimous shareholders agreements where the only two parties to the unanimous shareholder agreement might be the founder and his spouse, or the founder and his family trust. So he can largely control how that transfer is going to work and how the operation continues. So we do that. And if we take a step even further back, a lot of times, corporations have holding corporations, and there's different things we want to put in place. So we want to make sure that the opco has leases with holdco. If one kid's going to end up owning one corporation and not the other, and we still want the continued corporations to have to act together, we put leases in place, we put management agreements in place, and just make sure that we have the structure, the legal structure behind it to be able to carry on when it's not just one person making those decisions.
Darren,
Well, Amy, just to sort of expand on that a little bit, when we talk to clients about selling their business, right, and trying to maximize the value, and that value, again, might be dollars on an exit, or it might be a quality business that's being transferred to the next generation. It's we often talk a lot about housekeeping and just making sure all the internal agreements are in place. Like, maybe you can speak to that a little bit, like intellectual property, employee agreements, and suppliers, those types of things.
how about the human element in a succession plan or planning? Anyone have any comments into the human element as to the grooming of the skill transfer? Any maybe Darren make a stab at that one.
Yeah, yeah. Actually, if you don't mind, Jeff, I'm just going to hijack, and I'll get to that. The one other thing that I wanted to throw in when we were talking about, the legal agreements, and uh, so often people forget about the tax implications on an exit of a business. And Valkeep made a great comment earlier. He said, listen, lots of people, they don't think about it. And I have some wealth here, but I'm not significant enough that I need this advice. And, that may be true, but I mean, even if you have a business that's worth $1 million, there might be, hundreds of thousands of dollars of tax savings that can occur with the proper planning in place, right? And to most people, especially if you have $1 million business, $100,000 of tax is, that's 10%. That's a significant part of your retirement, right? And our ability to access, some preferential tax treatment depends a lot on the corporate structure. It depends a lot on the assets the type of the assets that are in the business, right? If we're going to go sell the business, but the business owns recreational condo in Palm Springs and like all sorts of other things, that complicates the transaction as well, both from a tax planning perspective. But now have I accumulated assets in this business that I'm transitioning to somebody that those specific assets I don't want to transition. I want to keep those for myself. And with all of this planning in advance, and having some timing before the sale makes a huge difference in the final outcome, financial outcome for
So
the
Darren,
entrepreneur.
before you finish your hijack, there was a question or two that came in from the audience here, for the participants here, um, about, like, I'll just go through one of them one at a time. But financing of transition between generations, like how does generational transfer, like what's your experience in that? Like, is there a common practice? Is there an uncommon, like what types of formats do you see in financing a transition between generations?
Well, I'll maybe start with that one, and I'm sure Amy's seen a lot. So just from example, I've seen it all, right? I've seen the family transition where the dad is just wants every penny. I mean, it almost could have been a third party sale, right? And when I asked dad, I said, how are they financing this? I don't know. That's their problem. Right? So, I mean, it can be traditional, third-party financing, whether it's, banks, other, capital lenders, things like that. Often it's, that we jokingly call it the bank of mom and dad, but it's more legally referred to as a vendor take back. So, the owner is, selling and saying, I'm willing to, lend the money to the next generation, to management, in order to buy it from me. So they're going to have to pay me back over time. That that creates some exposure and some risk to the owner, because you're not walking away with a bucket, a big bucket of cash. Maybe you have a small bucket of cash because you want them to have some skin in the game, right? I think that's always healthy. That's what we advise. But they're going to get paid back over time. So now all of a sudden the owner has a bit more of a, or the selling owner has a bit more of a vested interest in making sure the business continues successfully, so they can, realize their cash over time, and then that can perhaps create some conflicts with, the question that we bypassed that we didn't get to yet, which is sort of that human side of everything. But Amy, do you have any other comments on that with regards to
And I
finance?
think um, when we're looking at that was one thing. Like often we'll see parents come in and they'll either want to gift shares or they will want to do a partial sale with promissory notes or vendor take back financing and things like that. And I think one of the things then we typically try to address when we go back to the estate planning documents that Malky was talking about is making sure you have the proper documents in place. For example, if we've got one kid who's working in the business, who's got outstanding financing surrounding the purchase of the business, who has to step in as the attorney under the enduring power of attorney, and the vendor take back has has interest payments that are due but not being collected, all of a sudden we put that kid in a position where they're in a conflict of interest, because as a fiduciary, they're stepping in to maximize dad's interest in the loan repayments. And now they've got this self-interest that may have been an agreement between dad and them. But what happens to the three other kids in the wings that are saying, my value in this estate is tied to these repayments with the interest payments? And that's where Malkeet gets retained then to act for the other three kids who are saying, so these are things that you don't think about and think like, oh, the kids will be fine, or this will all get worked out, or we've got these simple documents we put in place 20 years ago that'll still work. But I think as a lot of people have significant wealth in corporations and they're transferring it, is the devil is in the detail here. And we then pass the file to Malkeet because he steps in to litigate these issues.
Yeah, I imagine that there's some complexity in the business owner still being vested in the sale and the continuance after the sale. So that there's the pro of, they want to make sure that it works, but there's the con that they're holding back the next generation's ability to succeed. Any comments on that? Darren, you shook your head. Have you seen both
Yeah,
sides of that?
yeah, no. I mean, you're absolutely right. So, I mean, when you start now talking about the human side, right? And it's, so the kids are, maybe one of the kids, or even some of the management. I mean, it doesn't have to be family. They've been in the business or hopefully around the business, and that would be part of the success is grooming these individuals to be able to take over. Um, but they've got their ideas, and they're going to have ideas that are different than what the founder or the exiting owner is. So, do have, is there an understanding amongst the parties that it's like, yeah, we're going to let them do what they need to do. And when mom and dad or, the seller has this big vested interest in it, and they provide, and they have a lot of influence on the successors. It's a question of whether they can do what they want, or is it going to start getting conflict. We're going to expand into this geographical area. We're going to expand into this new operation of business. We're going to, automate and some of our processes and reduce our workforce, and all of these types of things may be offensive to the founder, right? And then it creates some conflict.
And just to add one more possible wrinkle in that, one of our clients over here, they wrote their documents in a way that family cannot get involved in the business upon succession, even though they retained ownership, and it actually is like a wealth generation tool for the family, but they actually made it so that they cannot get involved in the business, and they allowed the managers to continue the business. And again, I don't have all the details of that, but I always thought that I never saw that permutation or option before. There was another question here on, and feel free to continue to add questions into the chat. Anybody has any, but I'll just keep going. U.S. born children. Does anybody have the ability to answer that on the fly here? U.S. born children, can they have a stake in a business, shareholder, directors, officers, passive income? Is there any, like, is this in a tricky space, or is there black and white answers on this one? Malkeet, it looks like you have a half answer coming out. Go ahead.
Amy and I always talk about how we're not cross-border tax experts, but we wish we had had enough skill to become those at some point. I think we typically will defer on this one, and fortunately, having to throw this to Darren, but we do typically defer to our accounting partners to be able to provide us with some answers whenever it comes to American citizens who might have some interest either in an estate or a business. The tax complexities involved in that are outside of my particular area of expertise, and I wouldn't want to ever give advice to somebody who may find themselves in a situation where the legal advice conflicts with the tax advice that they might receive from someone like Darren. However, anytime you have a foreign citizen who might have an interest in an estate. There are going to be multiple levels of tax issues that are going to be arising both on the Canadian side and in that individual's citizenship jurisdiction as well. So for that reason, I think it's best we always tell people, you need to seek advice from your own accounting advisor, both on the Canadian side and on the American side, to make sure that you're compliant with all of the tax rules, and that we will paper whatever the accountants advise us to paper on behalf of that individual to ensure that advice is actually sound. Just to go back one, I guess the other question that you had asked, Jeff, which was in terms of how to structure these deals between the current owner and the next generation, and some of the things that we may have seen in the past. I think a lot of, the type of structure or the deal that gets structured might have to do a lot with the timing of things, right? If depending on when the individual wants to transition that business to the next generation will, I think, oftentimes dictate where or what sort of deal is going to be struck between the parent and the child, for example. If a parent is looking to transfer shares to a child's name now, and there's still many, many years that the parent is going to be around, perhaps there's ample opportunity for that individual to pay back some sort of a promissory note. There might be vendor take back share that might be more effective there. But the more important consideration is, are there other individuals in the family who are going to look at this child as receiving the benefit of these shares and going to create problems down the road when the parent passes away, regardless of the timing and how it was all set up. That's the human element that you can't control. Oftentimes people in a family will have their own version of the truth. And if a parent passes on a significant amount of wealth to one child, and the child then takes over and creates an even bigger, more successful operation from that, the children who didn't receive that benefit while the parent was alive may hold a certain level of animosity towards that sibling who received the benefit, and they didn't. So those are the kind of things that you can't control, and I think, but paying attention to those things as a possibility or a reality that could exist in a family requires you to have some hard conversations and take a look at your own family situation to see if there's any sort of a risk of that coming to light at some point in the future.
I think if I can expand on what Malkeet's saying, it's I think a lot of times people know in the back of their mind what they want to do. It's really hard to say it, but I find a lot of times when we're meeting with people planning or just talking about these kind of conversations, no one wants to start the hard conversation, but once the conversation started, there's, I think, a sense of relief. So I always encourage people, talk to us, talk to Darren. It's hard to air your dirty laundry. It's hard to say, I have a kid that might be a problem. I have this issue, but addressing it is way better. And I think it takes a lot of stress out of moving forward, knowing that there's a way to address it and to plan it. And honestly, for us, it's not the first time we've heard this. It's not the second or third time we've heard it. So we do have the tools and the strategies to help deal with it. So I always say, just bite the bullet and have the hard conversations and give us the information we need to know. Like if you have a kid who has a problem with money, or you have another child that has a disability that we have to deal with, there is a sense of relief from dealing with it and setting up structures now instead of leaving it to blow up on the back end.
Thanks, Amy and Malkeet. Yeah, it's definitely, there's a lot of complexities in it. When somebody passes away, I've seen some of those stories that Malkeet was mentioning, that the family got torn apart in the future direction of that capital being utilized in different ways. So, Darren, did you want to chime in on this one before I bump to the next question?
No, I think we're good. I think we're kind of covered off there. Thanks.
Okay, and did you have any comments on the U.S. Tax treatment and any comments around that?
Yeah, so I mean, I guess my general advice is it is a complex area. From my experience, similar to Malkeet and Amy, we don't provide opinions on cross-border matters, where we're specialists in the Canadian realm. Where we've ran into problems is having clients understand that just because you're talking to a Canadian accountant doesn't mean they know anything about the US. And just because you talk to a US accountant, they don't necessarily know what happens in Canada. And it's so you'll find where, and I'm dealing with this situation right now where the US accountant's telling them one thing, I'm telling them another thing, and that's because we're not talking to a cross-border specialist. So that's really the key, is somebody that understands the integrations of the two tax systems, and that helps out a lot. But now it's just a general question, not so much a problem having a U.S. Citizen involved in a business. It has more to do with their residency, right? Because yes, they'll have to file a U.S. tax return, but if they're living in Canada, we have lots of U.S. joint citizens that are clients that live here. Generally, we're guiding our planning around the Canadian rules because the U.S. rules are less relevant because they're filing down there as a non-resident U.S. citizen. Where we do run into a few more problems is when the person's a U.S. resident, and when we start talking about estates, it's kind of a all stop with us if we have a U.S. or non-Canadian non-resident executor of an estate, because that creates all sorts of tax problems on the estate side, because now we have a foreign controlled trust, and the rules are very, very different than what they are for Canadians. So generally with my clients, as soon as I hear it's like, oh, hey, Sally's, moving to Texas, and it's like, okay, let's make sure Sally is not the executor of your will.
I would
So I'm gonna
add to that, if someone's adamant that they want to, then we can take steps to make sure that they don't have control of decision making to try to limit that. But Malkeith said it, but I think if you have U.S. tax issues, or you have cross-border planning issues, address it and understand that it's going to be more complicated. And, Malkeith and I are going to we're going to call up a US lawyer and a US cross-border tax expert, and we're going to give them our Canadian documents and say, make sure these work under US tax law too. And, I'm involved in an administration matter right now. And so I think it's just another beware of the issues. They did address that. The estate planning was done to address the US estate assets, but there was a disconnect between the corporate accountants and the personal planning done, and so it's a really complicated area. And there's income tax considerations that can arise that may be an issue that you need to deal with your accountants more so than your planning lawyers. So I think if you have that, make sure you're getting the right advice, and if you don't have that, reach out to Canadian professionals who have the connections to connect you to the people, because there can be a lot of unintended consequences.
So I have a few kind of questions I'm trying to combine together here. It's let's the good and bad and the ugly, like the concept of that. Let's play with the bad and the ugly for a moment. Like, and I'll just go line by line. Like, so on unanimous shareholder agreements, what's some risks or some ugly out there? What are some bad situations you've run into or seen? Obviously, I know you can't share particulars because everybody operates under ethical oaths and confidentiality requirements. But give us some general themes that you see that
I would
are
say, yeah,
Go ahead,
I
Amy.
would
Yeah.
say probably the worst one that we see, and not entirely we see it more often than not. People draft unanimous shareholders agreements and then they don't sign them. And, and then we're dealing with an administration or a shareholder fight, and we're like, well, you banged this out for 6 months and then got tied up on one issue and never signed it, so you don't have an agreement in place. So that one's top of mind because it was something I was working on yesterday. So I would say if you draft a USA and you negotiate it, make sure you sign it.
How about you,
Well,
Darren?
and I agree with that. And it's whether you draft it, I sign, but make sure you have one in place, right? Because so often it's one of those, hey, we're in this business together and everything's fine. Well, try and ask for a prenuptial agreement when you've already decided that your marriage is over. right? Like it's too late. You need to do these things, and then even in the context of, maybe it's just that, you could have one owner, right? Who potentially now, when that owner passes away, the shares go to the three kids because that's what the will says. But now there's no, without a shareholder agreement in place, there's no opportunity or guidance as to how do they play in the sandbox and how do they buy each other out if they disagree on things, right?
And that's,
Um,
I think we see that too, where just what you said, there is no USA in place. And I think sometimes people think, well, I'm the only shareholder, so I don't need to put one in place. But that's the best time to put it in place when you know that you're transferring that wealth down. Because then what happens is you get to a situation, if you don't have a shotgun clause or you don't have a right of first refusal, you've got someone that won't sell their shares, you're in a deadlock, or someone's controlling it, and then there's other people making oppression claims, and you've got court applications or a deadlock, and there's nothing happening to this corporation, and it turns out that it's getting liquidated, which isn't what the founder intended, because the parties, as you said, can't play in the sandbox together.
Yeah, I mean, I had a situation where it was, two brothers were shareholders, and the intention was that they would both be participating and active in the business, and the one was not performing because of, some personal challenges that they were going through, and and there was no shareholder agreement. So, like what Amy was saying, it was going to be a 2-3 year court process to remove the non-performing sibling from the business, and in the meantime the one who's running the business is frustrated because he's working hard and growing the business and growing some value for the benefit of his sibling that isn't involved, and it's just very 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 awkward. So that's the bad and the ugly, Jeff.
Keith, you were trying to get in. Do you have a good, bad, and ugly story?
Yeah, not too. I think the most important one here, I think both Amy and Darren touched on, is having just the lack of a USA altogether. I think creates the most problems when it comes to the good, bad, and the ugly with respect to USA. It's just not having anything in place oftentimes leads to this issue of just a vacuum in terms of how our decision is going to be made with respect to the company. The other one that I've found is the inconsistency between a USA, for example, and a will, where an individual in their will has directed that I want my shares of this corporation to be transferred to my son, my daughter, my wife, whoever the recipient of those shares might be. But the USA doesn't allow for that kind of a transfer to take place because there's a certain restriction in the USA as to how the shares are going to be dealt with. So having an idea of what the USA actually allows with respect to the transfer of corporate shares is an important consideration for a drafting lawyer when they're drafting the estate planning documents to ensure that there's a consistency between or what the individual wants to do after they're gone is actually allowed under the terms of the USA. So those are the only two things that I wanted to add to that.
But
So
I
let's,
think adding
sorry.
on that just for 1 second too, which we see as drafting lawyers a lot of times, is someone comes in and says, I own this farmland. I'm going to leave this to child A and I'm leaving the residue to child B. And then you find out that the corporation owns the farmland, and sometimes people will say to us like, nope, I'm sure, don't check it, don't do it. And Malkeet and I both check it and do it. But then we have problems when the gift fails to tell the child because they don't own the asset that they're trying to gift to someone because it's held by a corporation and the corporation's being willed to someone else.
Very interesting, yeah. Okay, let's transition a little bit to wills. Some good, bad, and ugly on the wills. Malkeet, I know this is your area of practice, so give us a common bad application of a will.
I could probably take 2 hours talking about the bad that can happen.
Well, I have a couple follow-up questions with you, Malkeet. So
in the
start,
absence,
and I got some more to go.
well, again, the typical problem starts as it does when it comes to USAs is the lack of a will. First of all, can create all sorts of issues for an individual once they pass away. And the lack of a will means that they have absolutely no control over who is the beneficiary of that estate. It's governed by the legislation. Who is going to become the administrator of that estate is governed by the legislation. There's really no choice other than to look at the legislation, the Wills and Succession Act, and see who is actually going to be administering and who the recipients of that estate are going to be. So lack of a will oftentimes might result in an individual or a group of individuals receiving a benefit from an estate that the deceased may have had no interest in ever happening. So not having a will has its own set of problems. In terms of the wills, the things that can arise, again, there's a multitude of problems. It's lack of properly dealing with the entirety of your estate, so that maybe a portion of your estate is still left open and there's a gap. So some of your estate goes by the terms of the will, but some of it remains an intestate estate, so dying without a will. And there's problems in terms of the selection of executors. You might have 2 or 3 executors that you've appointed. We never recommend more than 2, but some people insist, they think they're going to upset one of their kids if not all 3 of them are named. And we always warn against the problems that can arise when more people are involved in the administration, just because of personalities and the human element, as we go back to. Not everybody's going to get along. Not everybody's going to be agreeing on all the decisions that need to be made when they're administering an estate. So having more people named as executors who might start, arguing and disagreeing on all sorts of decisions, starting from day one when the funeral has to be arranged, all the way up until obtaining a tax clearance certificate at the very end of it, and then distributing the funds. So having too many people involved in the decision-making process, not addressing the entirety of your estate, not having a will, and one of the big areas of litigation that we often see is it's around resulting trusts or gifting things that you have no ability to gift. So a building is owned by a corporation, but yet in your will you've gifted it to your 3 children, and the USA prevents that sort of a gift or the transfer of those shares to be done in that manner. So like Amy was talking about, just not knowing who the owner of a particular asset is and kind of conflating individual ownership with corporate ownership, which is oftentimes still the case. It happens. People think they are the owner of the company, and that company owns a piece of land, and therefore they own that piece of land, which legally isn't the way it works. Even though technically, yes, they are the shareholder and they are the owner of that property, but there's certain things that they can't do when there's a corporate structure in place. So multiple rise, Jeff, like I to pinpoint a particular example, a lot of it again comes down to the human element. The problems arise when you haven't considered the interpersonal conflicts that can arise when you're selecting your executors or your attorneys or your agents, not being truthful with yourself as to what the likelihood of that conflict arising. I think sometimes people wish or hope that their kids will do things in a manner that won't destroy the family, but that's sometimes just impossible. And there's just a number of problems that can arise. Amy probably has just as many war stories as I do. So
Yeah. Well, I've actually had 2 administrations this year with operating businesses without a will. And, they as soon as you die without a will, you have no one to administer your estates. The one we were like negotiating, they were in the middle of renegotiating leases. They had sole bank authority, so you're dancing around. And in the one that we didn't know who the beneficiaries are, so it's a little bit easier to say, okay, well, we know the intended beneficiaries, so we'll get them on side and do as much as we can until we get an administrator put in place. But on the other one, or if the beneficiaries are fighting or you don't know what you're doing, as soon as the competitors know we've got a business here that can't carry on business, can't make any decisions, you've got valuation issues and potential competitors coming in and saying, well, this is going to be great. And it takes longer. It's more complicated. You have to get a court order to put someone in place. And until that happens, your business is doing nothing.
So there's definitely a risk of loss of wealth in that process. Darren, I have some other questions to go, but if you have something on good, bad, and ugly on the wills, you're good.
Yeah, no, I'll be repeating, and I've
Okay.
seen many of the things that they've described.
So there was a question that came in, and I don't know if it's Amy maybe or Malkeet, but can you shed some light on the pros and cons of having a secondary will for the corporate assets? Can you just shed some light on that, the pros, cons, and or conflict that arises from that, from creating a secondary will for the corporate assets?
Yeah, so I can speak to that. So in Alberta, we don't really need those. Having a secondary will for corporate assets is largely a planning tool so we can avoid probate fees. So where we really see multiple will planning is in BC and Ontario. So I'm also called in British Columbia, so I do draft primary and secondary wills. And typically what we do is we put the corporate assets in the secondary wills because then we don't have to probate them. So we're saving on the 1.4% probate fees. And we only administer and probate the primary estate, which has the assets that have to be probated, like houses and cars and vehicles and things like that.
Okay, perfect. There was a question on you writing of wills using software like Intuit's writing software versus engaging with yourself, Malkeet. Do you have any comments on the process a will gets completed and as to its ultimate success?
Yeah, I think with there are a number of companies that have come out in the last few years that have offered online will preparation services. So it's not a new thing that's on the market. And I think even before these sort of platforms, there were, you could walk down to London Drugs or Shoppers Drug Mart and buy one of the drugstore will kits and fill it out yourself. So this idea of kind of do it yourself wills has been around for a long time. We always obviously advise our clients to seek the proper legal advice, particularly when it comes to dealing with an estate that has fairly complex issues that need to be addressed, including corporate shares and perhaps even interfamilial kind of issues that need to be dealt with, and then more so when you have potential beneficiaries who might have certain needs with respect to how a will needs to be set up, including maybe including some trusts for minors, trusts for beneficiaries who might have dependency issues such as addictions and those sorts of things. I've never used one of those programs before, and Jeff and I haven't really looked into them too much. And I don't know if there's an ability in those programs to kind of get into that kind of minute detail about how you want to set things up. But for fairly simple, straightforward wills, I mean, I've had clients who've I'm probating an estate right now that was done on, I think it's Willful. It's a estate planning platform that's come out, or it's an app that came out a couple of years ago, and it was done and then something that I can probate. But there's more, I guess, risk when you're taking those kind of shortcuts for the purposes of saving some money at the beginning. It could potentially result in your estate becoming more cumbersome and a bit more expensive to administer after you're gone, if you haven't dealt with all of those various things that I've just kind of touched on that a proper estate plan should be dealing with. Yeah, but I mean, I've had people who've done holographic wills, which they've just handwritten and signed and dated, and those are just as legally effective as a lawyer drafted will. So there's really no right or wrong answer here. It's just a matter of what a person wants to do, just keeping in mind that if you're doing it to save a few $100s at the beginning, depending on what happens at the end of your life, and who has to, or the lawyers have to get involved to clean it up because you haven't dealt with something in your handwritten will or your app produced will. You might not be really saving that much money at the end of the day, but it's individual preference. We don't obviously try to talk people out of doing it if that's what their preference is, but we would always recommend that you have it reviewed by your advisors. And if you don't want to spend the money, then those options are available, certainly.
I'm going to switch over to Darren for a second, and I know we're running low on time. We're done in just over 5 minutes. But Darren, on tax planning, because I feel like what Malkeet brought into this was the will is one piece of a tax planning puzzle. Darren, can you just describe corporate structures versus coordinating a tax plan. What are some of the best practices you see, or what would be your recommended process to accomplish?
Yeah, well, I mean, the question about corporate structure is always, it depends, and one model doesn't fit well for everybody. The other interesting thing is that tax law evolves over time, right? And a lot of the planning that we were doing 10 years ago or 15 years ago isn't as applicable today, right? And what maybe made sense then, and in some cases it's because that was a cheaper way to do it, and it kind of accomplished 80% of what we wanted, and it maybe was fine to operate for 10 or 20 years. But when we start looking at the disposition of a business, that's a family succession or a third party sale, the big tax savings right now is the jewel is the lifetime capital gains exemption on qualified small business shares or farm property. And roughly speaking, on $1 million value, that's 240,000 dollars worth of tax savings. So we're looking at, again, and I talked about this briefly earlier, and I won't get into all the details, but it's like, what are you selling? Like, are they all business assets? Because that's really important. But that exemption is also only available to individuals. So it's people selling shares, not holding companies selling businesses. And, we want to be looking at some structures in place that we can use mom and dad's capital gains exemptions, maybe the kids exemptions, right? How do we multiply that? If it's a $5 million business, we probably want 4 or 5 shareholders maybe to participate in that, because then we're saving over $1 million for the tax. And so there's a lot of planning that's done in that. Family trusts are becoming really common for holding those types of assets, and there's all sorts of other. That's another whole topic session, another hour that we could talk for 3 hours on. But we're starting to do more and more planning in that area so that we have some substantial tax savings on the exit.
Perfect. We're at the 3-minute mark, so I'm getting to the point of closing right away, because I think the platform may just kick us out. I'm being told it might not, but I always like finishing on time. So just a quick no, it won't. Okay, thank you, Samantha or Kate. Anyways, let's close it off, because I like finishing on time, even if the platform wasn't going to kick us out. And so I want to thank our participants, everybody that signed in today. We had 135 register. Thank you for your questions. And I want to thank our panelists. I want to thank Malkeet, Amy from Field Law, and Darren from KWB, and helping guide this conversation, which is important to all business owners. And sometimes it's more important than other times in all of our lives. And I know proper planning is required early. It's not at the end that you should be planning. You should be planning early. So definitely recommend that you get engaged with your lawyer and or accountant in these conversations as they start to arise, as you start to think about how does this work, upon succession, upon third party sale for the family you leave behind. I want to, let's see here. Just a couple quick things. We're going to get an email sent out. I think it'll probably be tomorrow, because it'll need some summarization notes from Malkeet and Amy and Darren in it, just to get out to you. Any key takeaways, any next steps. If you want to reach out to any of us, that'll be also through that email. But most importantly, we're going to have a survey. And we want to know what we did right, what we could do better, so that we could serve you better in the future. So please share your thoughts with us. And thank you, everybody, for jumping in today. Have a great rest of your day, and go Oilers, go.
Thanks, Jeff.